us. I'm going to let the speakers introduce themselves because I think they could probably do it far better than I can. So Nikki, as you're the first person on my screen, would you like to introduce yourself?
Yeah, sure. Hi there, everybody. My name's Nikki Bowker. I'm a partner in the Litigation Dispute Resolution Department here at Devonshire's, based in our London office, and Devonshire's are a corporate member of the Fraud Advisory Panel.
Amazing, thank you so much. And Sally?
Hi everyone, my name is Sally Clark. I am North Counsel with CMS. I'm based in their Edinburgh office. I specialise in corporate crime, and I'm here today to speak about the Scottish side of things.
Amazing, thank you so much, Sally. And Natalie?
Hi everyone, my name's Natalie Tenorio Bernal. I'm a senior investigator at a law firm based in London called Edmonds Marshall McMahon. And yeah, I specialise and work in the private prosecutions team here at EMN.
Amazing, thank you all so much for joining us. And just in case you don't know who I am, I'm Hope Sakely. I'm part of the Fraud Advisory Panel, and I help to lead on everything to do with charities and the work we do here. This topic has been one close to our heart for a long time. For a couple of years, people have asked us what the legal option is when charities suffer a fraud. And to be honest, I can't answer that question. So we brought together some fantastic experts to try and give you at least an idea of what your options are when you suffer a fraud. And that's kind of, yeah, where we'll start. So Nikki, if I start with you, but to both the other speakers, please jump in as you would like. We've got lots of definitions, lots of types of prosecution that we're going to be going through today. And that means we kind of need to get an overview of what they actually mean. So if we jump straight in with civil, kind of what is a civil prosecution? What is a civil action? And kind of what does that look like? What are we actually saying when we talk about that?
Yeah, of course, absolutely. So I would tend to divide the two sort of types of civil action by those actions that you might take immediately, very quickly after identifying an issue of potential fraud, and the action that you might take longer term with a view to recovering assets or protecting yourselves in other ways. But to look at the first category, and I'm trying to avoid too much legalese and that type of thing, because I know that's not helpful. But the first category of things that you might take immediately, these could be things that you would do within a few hours, a few days of identifying an issue. And that tends to fall in the categories of sort of injunctions. Now, that could be something that requires another party to do something, like provide you with information. It could be something that prevents another party from doing something, so disposing of an asset, so selling something or transferring cash or moving assets around in a way that might make it more difficult for you later down the line. And the other thing that an injunction could do is effectively preserve the status quo. So if, for example, you have a fraud where you're concerned that monies have ended up in the hands of a third party, either directly because they're involved in the wrongdoing, or even potentially innocent parties who unwittingly have been involved in the wrongdoing, then an injunction is just a form of court order that you can obtain that preserves that, and often that's called a freezing injunction. So it does sort of exactly what it sounds like, which it will freeze, for example, money in a bank account, which will mean that other people can't withdraw money. Doesn't mean that it's your money or that you get it back, but it effectively maintains the status quo. The bank will know that the order has been made, they're told, and they will hold that money in that account, for example, until the issue is resolved. So that could be held in that account for months and years, but it gives you the reassurance of knowing that nothing else can happen to that money in the meantime, whilst you're waiting for the case to proceed. In order to do that, and to get those types of injunctions and orders, you would usually instruct solicitors and you'd instruct a barrister. The barrister would go before the court and argue the case for you. And often in these types of cases, you can justify doing that without having to tell the other side, either the potential wrongdoers or suspected wrongdoers or any other third parties. You go to the court and you say, this is really urgent. It's so urgent that we haven't got time to tell the other parties involved. Or if we told them, it would effectively tip them off to what we're doing and giving them the opportunity to, for example, move money, sell a house, sell a car, whatever it is that they might be doing. So you would go, and you can do it within, a couple of days. You could do it on the same day if it was incredibly urgent, and the court will deal with those types of matters outside of normal working hours if it's really exceptionally urgent. So that's the sort of first category in terms of immediate steps that you could take to secure the position, prevent the position getting any worse. The longer term step that you would need to take is to issue a claim, and that's a normal civil claim. So in the same way, if you were having a dispute with a supplier or a partnership organisation or anything like that, a sort of commercial type claim, that's a civil claim. Again, you would need to start the process. There would be court fees to pay. You would instruct lawyers to help with that, and ultimately move that case towards trial, which, depending on how backlogged the courts are and when you can get that could be, if you were lucky, it might be 18 months, more likely 2 years to a trial, depending on how complicated it is. So that's sort of an overview of the civil proceedings without getting too much into the nitty-gritty of sort of terminology, but the stuff that you can do immediately and the stuff that you do longer term. And the stuff that longer term you do is with a view to actually getting back assets or the value of those assets. So if someone's taken an asset from you, they don't have it anymore, but you get a judgment that says you owe us for the value of that asset. So you're then trying to recover that value from them as well. And that takes a longer period of time. Those are the civil things. The criminal side of things, I won't touch on private prosecutions. That's obviously Natalie's area of expertise, and she will cover that. But it would be usual to consider whether to report a matter to the police at the time that you suspect a fraud has taken place. You report it through the Action Fraud portal, which is sort of web-based online form. You can be supported by lawyers in that process. Some organisations do that themselves, depends how familiar you are with it. But that's a sort of online reporting, and that would generate a crime reference number. Sometimes people will need that for insurers and things. Will come on to third parties, I know, later. And then effectively you're in the hands of the police, investigating authorities, prosecuting authorities, as to whether those public bodies, rather than you doing it privately, will investigate and pursue criminal proceedings. It's worth saying that you can keep reflecting on that. So the police might say, actually, there's nothing that we can think we can properly investigate at this stage, but you might, in the course of pursuing your civil claim, get further information months or even years down the line, and that can give you cause to go back to the police and say, actually, to be frank, we've done a lot of the work for you. Here's the information. Will you reconsider the matter? So you don't have to give up, or if you can't, if you don't get initial engagement from the police, and it may be something that your regulators expect you to do as well. But as I said, Natalie will cover off the private prosecution side of things.
Yeah, thank you so much for covering that. I know it's a massive part of the topic, and just because we've got the Scottish side in as well, I don't know how many people will know this, but Action Fraud actually rebranded this week. They're now called Report Fraud, but Action Fraud number still works. But just if everyone's getting confused in all of that, there are two at the moment: Action Fraud and Report Fraud for cybercrime, and also in Scotland you report to Police Scotland. You touched on the criminal, and then we're going to jump into private. I think maybe we jump straight into private just because it's to mix it up a bit. So Natalie, what is private prosecution, and what do we mean when we talk about it?
Yeah, so I'm going to be talking to you a bit more about the criminal legal options, in particular private prosecutions. It may be a term that you're aware of and familiar with. I know sometimes I meet lawyers who don't even know what they are. So in essence, A private prosecution, in the normal course of events, a criminal offence is investigated by the police, and any prosecution is then brought by the Crown Prosecution Service or any other state prosecuting authority agency such as the SFO. A private prosecution is any other prosecution that is not bought by the state. So it can be bought by an individual, a charity, a company, and you don't need to have standing. So anyone can bring a private prosecution, even if they're not the victim of a crime. But there has to be sufficient standing, nexus, and some interest that they may have. Interestingly, England and Wales is one of the only jurisdictions in the world that allows victims of crimes to prosecute privately. But in essence, there is no real mystery behind them. They operate the same way as a private prosecution, as public prosecution, exactly the same obligations and duties as on the prosecutor, on the private prosecutor, as it would on a public prosecutor. So we're seeing them being used more and more by charities. You know, one of the main reasons behind that, and I think something that Nikki kind of touched on, was the police just don't have, unfortunately, the resources to deal with these types of cases. It tends to be, in our experience, that these cases are reported to Action Fraud, and the generic report that you get back is that they have found no reasonable lines of inquiry. And you know, as I said, this is it's quite disheartening when you think that, you know, you've been a victim of a crime, you reported it and followed all the proper processes and channels and to getting this to be dealt with by the authorities, but ultimately it just doesn't get anywhere in our experience. So I don't know if we're going to go through a case study, but we've got a case study that I've worked on recently to kind of demonstrate how a private prosecution works in practice. So I can kind of talk about that now, Hope, or we can come back to it later.
Wonder if we come back to it just whilst we'll cover off a little bit about how things work in practice and the considerations we make when making our choice. If we're going to jump it, if we choose to prosecute or take legal action as a charity, before we jump too far away, Sally, we've already covered loads of jargon. We've already discussed private prosecution, civil. We've already discussed the fact there are lots of different options. What happens in Scotland? Is it the same?
Thanks, Hope, and thank you, Nikki and Natalie, for doing the hard graft, because I just now have to say, here's how Scotland is different and here's how it is similar. In Scotland, in terms of the civil options, it's largely the same as it would be in England. Differences are in terms of the language that we use. We don't want to be too legalistic, but there is a difference in the terms that you'll hear north of the border. So, for example, rather than an injunction, we will call it an interdict. We would instruct a solicitor and an advocate rather than a barrister. It's pretty much the same, but just a different term. On the criminal side, Hope, you've already touched on this. Action fraud, or report fraud as it now is, doesn't deal with crimes in Scotland. You would just report it directly to Police Scotland, and you have to do that through their main switchboard, which is 101. A difference from Scotland to England is that in certain circumstances there is a duty to report a crime to the police. I know when you're a victim that you would normally want to do that, but there can be certain circumstances where you are obliged to report the offence, and that is if you have grounds to suspect a crime has been committed and that information has come to you through your business, through your profession, and it is an indictable offence, which would include fraud, and where there are two people conspiring together. So if you think that more than one person is involved in the fraud, I would really encourage you to report it to the police as a matter of course. The other difference from Scotland to England, which is quite a major one, on paper, you can raise a private prosecution in Scotland, but in practice, it has not happened in over 100 years. This was tested quite recently in the Scottish courts. It is basically, without going into the nitty-gritty of it, it is a very high bar to be able to raise a private prosecution in Scotland. And it's a bar that, as I say, has not been met in over a century. Natalie had touched upon the fact that in England you don't need to have standing to raise a private prosecution. In England, in Scotland, it's the opposite. Before you even can get to the doors of the court, you have to show that you have title and interest to prosecute. So those are the main differences before we move on.
Thank you so much for covering that off. And just whilst I remember it before the end, Sally has written a help sheet which is coming out later in the week on this topic around the options for Scottish charities. So we've got criminal prosecution, we've got civil prosecution, we've got private prosecution, and we've got the options in Scotland. In practice, as a charity, what are the considerations? What should you be looking at as a charity who is considering these when it comes to which direction you want to take, if you want to take that direction? But your expertise, what considerations, what do you think you should consider? Also happy for you to bring in any case studies at this point as well, if you think that will help point us in the correct direction or the direction you think that we should all be looking in. Nikki.
Absolutely, yeah. I mean, I think probably the starting point is the cost of any of this, and the the ability of the charity to fund that cost. So in a civil claim, that particularly if you're going to go for the immediate help, so going to the court urgently without telling the other parties and saying, oh, we just need you to either freeze the assets in a bank account or prevent a property from being sold, or whatever the particular concern might be, that can be a pretty expensive process, and part of that is because it has to be done so urgently, effectively. The lawyers that you're using and the barrister you're using, you sort of drop hands and you're almost working on it sort of 24/7 just to get it ready, because obviously every hour that goes by is a risk that those assets might be dissipated or put beyond your reach, moved out of the jurisdiction, that type of thing. And in terms of the cost exposure of doing that as well, so if you get an order that says to a bank, I want you to stop anybody taking this money out of that account, you would usually expect to cover the costs that are associated with that bank having to comply with that order. Now, a bank wouldn't usually oppose an order, they wouldn't object to it, but they won't take that action without a court order. But once you've got it, they'll comply with it, sort of the letter of the order and no more. But you are fronting up the costs for that process and for the third parties to comply with that process. In the longer run, you would hope that those costs would be recoverable in a civil claim. So you commence the court claim to recover the costs, get a judgment saying that these people did commit the frauds, and hopefully recover money at the end of that. But you would have to be prepared to effectively front those costs for the entirety of those proceedings. You can, in some circumstances, get the court to make what we would call an interim order for costs, so you get some money towards your costs as the matter progresses. But what you should be prepared is, if you sort of start the process, particularly if you issue proceedings, you're effectively stepping on a conveyor belt and that conveyor belt is heading towards trial, and you can only get off it in a limited number of ways. You can get off it by reaching an agreement with the defendants to settle the proceedings, and that might include you recovering some of your costs. You could discontinue the proceedings, because so you can say, actually, we've changed our minds and we decided we don't want to do any of that anymore, in which case you would have to pay all of the costs of the defendants that they have incurred, or you wait and you get to trial. So one of the things to think about at an early stage, as well as the costs, is whether the charity has the appetite and the sort of resource and capacity in terms of management time and the organisation's resources to actually see that process through to the end. So I think that the cost is understandably a significant concern.
Does anyone else want to jump in with any other considerations? So we've got the cost. Is there anything else that you might be considering at this point, Natalie?
I mean, the other point is potentially the PR. So the media that you're going to get as a result of, in this case, taking a private prosecution. The overwhelming kind of feedback that we get from clients that we've worked with charity clients that we've worked with, is that there's a sense of relief and justice, and that's reflected in the media, and the kind of state of the police and the resources that they have is kind of reflected into why charities have had to take things into their own hands. So if you have a comms team and having them lined up with potential inquiries. This is the case study that I'm going to talk about. There was press in the court hearing, and it was reported the next day in the Daily Mail. So being prepared to think about what lines are the charity going to take on this, providing contact details and potentially a prepared statement is something that you might want to consider as a potential outcome or consequence of taking legal options.
Well, yeah, so the reputation, all that kind of stuff comes up. We see it so often with charities making this decision. It is a hard one. It is a conversation. It shouldn't be done in a vacuum. Any other considerations at all?
I think for me, for some organisations, they will consider at that stage their regulatory obligations to have whichever organisation they're regulated by, or potentially more than one, of course. So that's not to say a regulator will mandate that you take a certain step. In my experience, the position that the regulator is looking for is, first of all, assurance around what's happened, what's been done to prevent it happening again. The regulators can sometimes be very keen that you do take action, but in my experience will respect a decision. So, for example, if as well as the costs, what goes alongside that is, what are your prospects of actually succeeding, and what does success look like? So in a civil claim, success probably looks like some sort of financial recovery. So is there a likelihood that that's what you're going to be able to achieve? And that's a perfectly reasonable thing you should properly consider before dedicating charities resources. You don't want to throw good money after bad, is the typical saying at this stage. And in my experience, regulators will understand that you have to sort of take into account that cost versus benefit analysis. What's the likelihood of success? Are the assets still available? Are you going to be able to recover them? Do the defendants have any money? Are they in the jurisdiction? Things that might make it more complicated. But one way of demonstrating to the regulator that you are taking matters seriously is obviously through litigation, but ultimately the organisation has to make the decision as to whether that's the right thing to do. But I know that some organisations at that feel themselves in a bit of a pinch with regulatory pressure to sort of hold people to account.
Amazing, thank you. So I so desperately want to hear Natalie's case study that I think it's time that we jump into kind of, what does it look like when when a charity does decide, and kind of, I don't know if you've got it in front of you, but Natalie, what led to this charity kind of making this decision?
Yeah, so yes, I think the easiest way to kind of take you all through the steps of what involves a private prosecution is kind of bringing it to life with a case that we worked on recently. So we worked with the UK's largest sports charity, and this was in relation to grant fraud. But we've worked on various other cases with charities relating to donation fraud, and more recently, insider, so an employee, a former employee who was putting their hand into the till. So this particular charity, as I said, offered grant programs of up to £25,000. And the applicants had to provide a number of documents as part of that application process. The first being a supplier invoice, which showed that they had paid either the product that they were applying for the grant in full, or that they'd paid a 25% deposit. And also a bank statement showing that the bank account details of the name, the sort code, account number of where the grant monies were going to be paid into. It all kind of came about because one of the grant executives within the charity noticed that one of the invoices didn't really look how it should look. So it was more of a hunch and a suspicion that something didn't fit and something didn't feel right. They went along with that hunch and called up the supplier and said, "Can I just check whether this invoice is genuine or not?" Transpired that it wasn't. And the charity at that stage took the initiative to dive deeper into this and to really understand the extent of what had happened, and whether it was just one isolated application or whether it was wider than that. So they instructed external forensic accountants to look into their processes, and alongside that to flag any discrepancies that they could identify. So it turns out, I mean, in the background, I should also say they reported this to Action Fraud, and there was a number of issues with the Action Fraud portal, which I won't go into, but it was discovered as a result of that work that an individual called Mr. White, for a number of 2.5 years, had made 34 fraudulent grant applications for grants, seeking to obtain just over £230,000. He received just under £200,000 of that money, and they were able to stop £31,000 going to Mr. White. So we were then able to, so this is where we kind of use the civil remedies. So we went to court and we were able to get a court order, a disclosure court order called a Norwich Pharmacal order for some banking information, because Mr. White had used 9 different bank accounts in all sorts of different made up names to get these grants. And the next step then was to just follow the money and see what had happened to it. Lo and behold, nothing of what was the grant was meant to be used on was actually used, and we could see from the bank statements that he was travelling the world following the England football club. He went to Qatar to the World Cup and went to Malta and Spain and Italy. And he put all of this very helpfully for us on Twitter and on Facebook. And so it was great evidence to show, well, we can see in the bank statements you've spent the money, and you've just confirmed it by posting a selfie by the pool or posting a selfie in the football stadium. So yeah, we also found that the invoices and the documents that was suspected to be forged, it spanned all the applications that he had made, and the documents really just told lies about themselves. As I said, they were mainly supplier invoices, bank statements, made up with all sorts of wonderful different names. So we had got to that stage, and the response that was given by Action Fraud was that they had found no reasonable lines of inquiry and that they weren't going to take it any further. I mean, at this stage, we had numerous bank statements, witness statements from suppliers confirming that the invoices had been faked. We had the genuine bank statements. So again, we had selfie images of Mr. White setting up these bank accounts, his passport setting up these banks. So we knew that he was behind all these accounts. We would have considered inviting Mr. White to attend what we call an interview under caution. So because we're not the police, we can't go and knock on his door, arrest him and bring him in for questioning. So we invite them and we conduct the interview in the same way as the police would. We didn't think it was necessary in this case because of the amount of evidence there was. And we also didn't want to tip him off into doing a runner or whatever. But it's a decision that we take on a case-by-case basis. And so we'd got to the stage where we knew that Action Fraud and the police were not interested, were not going to take any further action, despite getting to the stage of having all the evidence. And so the charity in this case decided to proceed to what we call laying an information at the magistrate's court. Laying an information, in essence, is providing the magistrate with a case summary. In this case, we also provided all the evidence and details of what we allege the offences that have been committed. The magistrate then applies a test, the legal test, and if all has been satisfied, criminal proceedings commence. And then it pretty much, as I said before, runs in the same way as a state prosecution. The charity then stepped into the shoes of the prosecutor, and at the first hearing, which is in the magistrate's court, the defendant, in this case Mr. White, had to plead guilty or not guilty. He pleaded guilty, which was of great result. He pleaded guilty to fraud and forgery offences, and it got sent to the Crown Court. And within a few weeks, Mr. White was sentenced. He was sent to 32 months in prison, and he was suspended for 10 years, disqualified, should I say, for 10 years as a director, because he created fake companies, again, to further the fraud. If he hadn't pleaded guilty, then it would have gone to trial. And again, it would have, the private prosecution process would have played out the same way as a CPS state prosecution. I think I'll cover later on about costs and confiscation, but I'll stop there for now.
Thank you, Natalie. It's really helpful actually to get a look at kind of what led into it. Was there, when the charity was deciding to take this on, because obviously it would have been a conversation, was there anything that came up in, I don't know if you guys know, you get involved at all in this don't know how I'm going to word this, which is why it's got a bit wrong, but kind of what goes into that conversation with what they want. I guess that comes back to Nikki's point around what do you want out of taking this procedure. Is it just I want the money back, or is it more than that?
So I think one of the main things with a private prosecution is, what is your motive? So why are you bringing this? And this is something that the courts are interested in, want to know what the motive is of the prosecutor. So in this particular case, it was clear that this was such an egregious fraud over a substantial amount of time, and they were constantly asking every day, have you heard back from the police? Have you heard back from the police? Are they interested? Are they going to do something about it? And the ultimate unfortunate answer was no. And I think they felt that they had to set a message. This is a big part of what the charity does. It's providing grants to grassroots football. And so they had to look at the deterrence effect that this would provide, especially when someone's going to prison. It's, a conviction is gonna make their lives a lot more difficult, and so it sends out that message to people who are thinking about it, that this is something that they're going to take seriously and take all the way, and seek justice, to put it bluntly, really.
Oh yeah, thank you for that. Sally and Nikki, have you got any comment on this at all? I've kind of thrown you both in the deep end by asking that question.
I was just going to add, I think Natalie has drawn out a really interesting point from the prosecution side of it, whether it's a private or a public one, but the additional deterrence that may come on convictions such as a director disqualification order, that there's a broader picture than just the victims, that this is, a 10-year DDO is really going to prevent that guy from trying to go out there and do it again. He will be out of jail after, however many months. But those are tools that are available in a criminal case that you wouldn't necessarily get in a civil one. The insolvency service can raise these separate civil proceedings, but not on the back of a civil fraud. And that is something that may be relevant when you're considering which option you want to pursue.
Yeah, thank you, Sally. Nikki, anything from you?
No, that's fine. And I mean, Natalie obviously made a very important point in relation to motives, and in respect to the criminal proceedings, the court is very engaged with that point, as Natalie says, in terms of private prosecutions. In terms of a civil claim, effectively doesn't matter what your motivation is. If it could well be to bring them to account, it could well be to shed the light on the issue, make an example of someone, particularly if it's an employee working in collusion with an external party. Sometimes the motivation is to take back as much of your money that they've ended up with as you possibly can. Sometimes it's to put them in a position where their business isn't viable anymore, or bluntly, it could be to try and inflict as much damage on them, as you can within the realms of what you're lawfully allowed to do. So sometimes the motivation clients have is just, think, as Natalie said, that it's egregious, and that they want to make those people's lives as difficult as possible. And as a sort of typical example, rather than a specific case study, but that is something often that can be achieved through the freezing injunction that I referenced earlier. So to get an order from a court that says the bank will not permit you, other than some basic living costs and some legal costs, and the amount of those would be determined by the court. Other than those amounts, you won't be able to access any of your money in those accounts or the accounts of the business or your company. It can include, quite often we have cases that are involving spouses where the sort of primary offender, if you like, would be one of the either the husband or the wife, but the money has flowed through a joint account or ultimately ended up there, or in some way, or it's paid the mortgage on the family home, and so then the freezing order can encompass the joint account. So that creating a situation where with no notice someone is not able to access their own funds, or what they say their own funds are, obviously causes real pressure on people, and often that can be used as leverage to reach an agreement. So it could be, in the short term, you can't access any of your cash, and we'll consider doing a deal with you and not pursuing the proceedings any further, if you agree to hand over, all of this, or we'll take security over your home, or repay the money over a period of time. And that's something that typically can work very well, because, to be frank, it's also expensive for the defendants to defend the case as well, and they haven't got a choice. You know, if you bring a case against someone, they've got to defend it or admit that they're at fault. So often a defendant is looking for a way out as well, and that can be a win for a charity, because if you get that at an early stage, you're saving the money that you would have spent, and also the huge amount of sort of the time and the stress that can be involved in being this case. You know, it will take over days of your working life when you would be out doing something on behalf of a charity, you know, behalf of your organisation. So that immediate pressure can leverage and sort of an early result, and that is something that typically would happen, you know, would happen in a typical case on a civil basis. But that sort of commercial leverage settlement discussion is obviously not something that you can have in the forum of a private prosecution, but you can do any deal that you want in civil litigation.
Yeah, and I think it's worth noting, once you've commenced criminal proceedings, you know, you're on that track, and it's very, very difficult. There's a high bar to kind of stop a prosecution once it's in court. But you have, I think, very similar kind of tools available and powers once it's in the criminal court to restrain assets. So kind of similar to the freezers, you can restrain assets in bank accounts. You can put notices on property that the defendant might have. So again, they're only allowed to spend X amount, or, you know, the court only allows them to spend X amount to cover their basic living expenses, and the rest is pending the outcome of the criminal proceedings. Might be worth me touching on costs then. Very similar to civil cases, this is a legal option that has to be funded up front. And so it is something that charities will obviously need to consider, the costs of doing so. One difference between the civil and criminal is, so costs are not paid by the other side. Generally, defendants don't tend to pay the costs. They can in certain circumstances where they have funds to do so. But if not, then costs in private prosecution are paid by the central government, and it's an application that you make for costs in your case. It's irrelevant. So if the defendant is found not guilty, so if there's a trial and they're found not guilty, then considering that the private prosecution has been brought properly, then you are entitled to costs. So it's irrespective, in essence, of the outcome of a trial, those costs, because those costs, you are entitled to those costs. And the reasoning behind that is because, in essence, you've stepped into a public function of, discharging, justice, and you've stepped into that role of what a state prosecutor would do. And so there is that provision in law that entitles you to recover those costs. And then just one final thing, if I may, is just around what happens once, they've been found guilty and they've gone off to prison. The other point that we have in criminal proceedings is what we call confiscation and compensation. So they're different parts of how the criminal justice system work. But in essence, if we can show, in this case, Mr. White benefited and took £300,000 away from the charity, that he has, assets, but we don't know where those assets are, and he's done a good job of hiding them away. We're able to apply to the court for a confiscation order for that value, and it's up to then the defendant to show that he doesn't have the money. So the burden then shifts from the prosecution to the defendant. And if an order is made, the defendant has to pay up. And if they don't pay up, they get more prison time. So it tends to be an incentive for money to suddenly appear, rather than spend another 7 years in prison. And again, compensation is another kind of realm of that funds that are confiscated are then paid in compensation towards the losses of the victim, which in this case is the charity. So a long-winded way of saying ultimately there is a way to if there are funds for those to be recovered as well.
Thank you, Natalie. So in 45 minutes covered an incredible realm of just the legal minefield that is available to charities. I'll say now that if anyone has any questions, the Q&A box is open, and we'll see if we have any time to field any of those, if there are any. But Sally, I'll pass it on to you, because we're a lot of lawyer talk, lots of talking about instructing and bringing people in. Lawyers aren't the only people you could go to for advice, or you might be directed by somebody else to go to a lawyer. Anywhere else that you'd go to, like beyond the legal option or beyond just the immediate, like going straight into London trying to find a lawyer to help you out? Are there any other places that might help direct you in the right place to start all of this?
In Scotland, the Scottish charity regulator has a very good website with guidance, and they would also be able to help you. Resources like Citizens Advice do very good kind of overviews. Obviously, all the fact sheets that are available on your own website. I hope a good plug there. There is that. You don't need to jump in straight away and commit. And as I think has been drawn out in this session, the decisions that you take, you're not bound by going down one route, whether that's a prosecution or pursuing a civil or both. And these are very much things that you can keep under review, and as things may change, or as your assessment of the situation, your risk appetite, and this is all fluid, and you can just reassess as need be as you move along the journey.
Amazing, thank you so much. Yeah, regulators are a fantastic resource, and I think as much as they seem like big, scary, omnipotent charity commission beings, they are actually really helpful when it comes to something going wrong. They spoke yesterday at our conference about AI and the fact that if something goes wrong with using AI for a first time, it won't always mean that it's a slap on the wrist. They understand you're learning as a charity, as is everybody else. Nikki, anywhere else that you'd go?
Yeah, it's always worth reviewing your insurance policies and speaking to your broker as well about the your policy position, and that can be helpful in two ways. It could be that you have an insurance policy that will cover your legal costs, so that would be sort of legal expenses insurance within a broader policy. Larger organisations might have, it used to be in the olden days called fidelity insurance, now it tends to be called an economic crime policy, but you might have a policy that specifically helps you in cases of fraud. And indeed within those insurance policies there may well be a sort of 24-hour helpline that you can ring, and often there is, for that sort of initial advice, even before the insurer is able to confirm whether the claim is covered or whatever. But you may find that your insurance has an immediate helpline that can help you, and then thereafter may help you to cover your legal costs, also the costs of investigations. And so it's always worth reviewing those policies. And if you've experience significant frauds, or you consider there's an activity you're about to undertake as an organisation which you think might be higher risk, you can always look at covering that in advance through an insurance policy. So that's always worthwhile checking on.
Amazing. Anyone from you, Natalie? I don't know if I even gave you this question ahead of this.
I mean, no, not really. I think we've covered most things, but I was just going to say, your peers, really. I think there are so many other charities out there who've got established for fraud investigation type departments, people kind of spearheading this type of fight against fraudsters. So, you know, whether it's, you know, reaching out to Hope and hoping, you know, she can put you in contact with someone who'd be willing to speak to you, that there it is a community that is willing to reach out and go that extra mile to help others out.
Yeah, I mean, totally agree with that, because the options, but most of the charities that we work with the Charities Against Fraud group, have picked one of these options in the past, even if it is that do nothing option, because they have to consider the amount of people they have to give up, or the time. All of those things make a big part of the consideration. So yeah, reaching out to peers, being in those groups, seeing other groups, other charities actually undertake this stuff. There's quite a lot in the media at the moment about it. If you just Google charity fraud, you'll find a couple of cases pop up immediately. There are no questions. So I wondered, oh no, well, I'll read this and I'll ask a question to all of you at the same time before I ask you the question. But if you could take one takeaway for a charity who's considering taking a legal option, whichever legal option you guys want to suggest, is there one thing that you, as experts in your field, think charities should either consider or have in the back of their mind ahead of either contacting you or getting the ball rolling? Obviously, I've given this to you guys out of the blue, so I'll give you a second just to consider. Whilst you consider, I'll plug the rest of the week. The rest of the week is still jam-packed. We have a fundraising fraud webinar that was pre-recorded. That's coming out tomorrow. As is our AI webinar, which is live and at the same time tomorrow. And we are in Glasgow tomorrow as well. So if you're a charity in Scotland, please come along. It's going to be great. We're going to look at ECTA and cyber crime as well. And then there are help sheets being released, one by Nikki and one by Sally. They're coming out in the latter half of this week. So there is still lots to come in Charity Fraud Awareness Week 2025. I really hope I've given you all enough time to answer the question that I've asked you. Natalie, shall I start with you?
Yeah, I mean, I'm going to choose private prosecutions because I can talk to it. But in essence, I think that the key consideration is what are you seeking to achieve with all these things? With any legal option, really. Ultimately, you know, the first port of call with any of this, as we've said, is report it to the police, report it to Action Fraud. That should be something that you should be considering from the outset to do. But ultimately, there are moments and there will be times where, you know, the assets have been spent. You know, the money is not sitting in a bank account. The defendant doesn't have a house, but you know, they've splashed it all away on lovely holidays. But, you know, ultimately, it's for the charity to consider what are they hoping to achieve with bringing a private prosecution, and the main kind of allure to it is ultimately, you know, the messaging that it sends out to people who are looking to exploit your grant systems, your donation systems, but also, you know, potentially taking action against individuals within your organisation. I think something that came out yesterday, so we were at the London conference, was charities seem to get the rap that, you know, they're soft touch and they're the caring sector, and, you know, they don't really, you know, do much when it comes to these sorts of things. But in my experience, you know, it couldn't be further from the truth. There were so many stories yesterday of charities, whether it was bankrupting an individual, whether it was a private prosecution, whether it was pursuing a civil claim. You know, charities are taking this seriously and putting resources to make sure that whatever legal option is chosen isn't having the deterrent effect that they want.
Amazing, thank you, Natalie. Sally, any final points from you?
I would just echo what Natalie has said about, you know, the objective. What is the charity looking for from, you know, whichever avenue they pursue. But on the back of that, I would say that, you know, whichever route they go down, that there has to be a realistic expectation about timescales, and whether you're investigating that for civil action or whether you're assisting the police with a criminal investigation, these things are going to take a lot of time. But then on the flip side, if you decide that you don't want to pursue either avenue, you need to make sure that you're not exposing yourself to that happening again. So rectifying your situations and making sure that you've got procedures and policies in place and training people, that's going to take a time commitment as well. So, you know, doing nothing is it in itself will require commitment.
Amazing, thank you, Sally. And then Nikki.
I think probably, yeah, obviously Natalie and Sally have made very important points there, and, you know, and echo what Sally was saying around sort of cost, resource, capacity. And it can be easy, if you like, in the heat of the moment, just after uncovering a fraud, and think, yeah, we're gonna really go after this person. Is there still that same appetite when it's 6 months, a year, year and a half, 2 years, sort of down the line? And you know, reflecting on what's right for your organisation and how you're deploying your time and resources, and think, you know, and the saying is, you know, prevention is better than cure. So if the outcome of that is you've identified, for example, you should improve your procurement procedures, or you need to make sure there's some additional process in place for scrutinising grant applications or whatever it might be, weigh up the potential value that you might get about investing necessarily a finite pot of resources into improvements versus what you might hope to achieve out of litigation, you know, bearing in mind the people that you're dealing with, the likelihood that you're going to recover everything or anything, the likelihood you'll be successful, that type of thing. Think about steps that you could take to have prevented that, and learn from it. And often, just touching back on the regulatory point, that's what the regulator's looking for. Nobody is immune to fraud. All organisations, businesses, firms, etc., experience fraud. Regulators aren't expecting you to be fraud proof, and indeed should always be concerned if somebody says, no, we've had no instances of fraud or attempted fraud this year on your sort of annual reports. But you know, it's the steps that you take to deal with that particular situation, but also to improve and hopefully at least minimise the risk of similar something happening again.
I think that's a perfect ending point, talking about looking back and actually taking, after a fraud, if something bad happens, make a change, changing policy, making sure that you are as safe as you can be. Again,